increase of 2.1 million jobs in the U.S. if Chinese infringement of U.S. IP rights was reduced. Now that could be a subjective calculation. In the face of all this infringement, however it's quantified, on the other side of the Pacific, the Chinese IP docket has rapidly increased, yet foreign companies, including U.S. companies, are less willing today to bring litigation than they were 2 to 3 years ago. A slight decrease. And as a percentage, we are at about 2.2%, all the foreigners, of the civil IP docket. In fact, there's about 3 times more maritime cases in China involving foreigners than there are IP cases. There's a problem. We can argue about the reasons for the problem, but one way the problem manifests itself is in U.S. companies bringing litigation in the United States for infringements arising in China, or finding other ways of addressing the problem. Now, some of them may be a rather aggressive extension of long-arm jurisdiction or other existing concepts. Some of them are creative extensions of pre-existing doctrines. Right now, in many states, you can bring a case against products being sold that benefit from infringing inputs, particularly piratical software, as an unfair act under relevant state fair trade laws. This is a creative extension of fair trade jurisdiction that the FTC and other agencies have looked into. Yet, if you look at Chinese behavior, and I think Judge Chin's discussion of the drywall cases points this out, when Chinese defend themselves, or if they have a rational defense strategy and don't simply default, frequently they don't do too badly. In Section 337 cases before the U.S. International Trade Commission, where Chinese have a record of losing many cases, the reality is that when they appear and defend themselves, their likelihood of success is better than average. So there's also a problem in the way Chinese are unwilling to subject themselves for whatever reasons. And some of them may be related to knowledge of the system, some of them may be related to fears, justified or otherwise, but they back off from engaging in the system, and sometimes they suffer the consequences. If you look at IP infringement as a systemic system, a market, the reality would be that an intelligent rights holder would normally prefer to bring a lawsuit in the country where the infringing products are manufactured. Stop the goods at their source. Bringing a case in the U.S., provided you have the rights in the U.S., will only protect the U.S. market. It won't protect you in Europe, it won't protect you in Japan, it won't protect you in any of the other markets in the world. Yet, the numbers show that litigation and other efforts to address IP-related infringement in the U.S. are increasing, and the amount of litigation in